Welcome to Senate Education, Tuesday, May 9th, 2018. I want to thank Senator Jewett for her report today on page 461. It was great. It's very helpful and well thought out. We just have that one question that I saw Senator Hardy in the hall. She's going to talk a little bit to the Secretary of State's office. We've also heard back from the Secretary of State's office with no objections, just saying it's a policy decision. And hopefully we will. I know talking with Senator Hardy, she too is hoping that we're not looking to slow anything down. So hopefully that will move, and that gives the House plenty of time. We have two pieces of business, S-138, which we'll do side by side today, an act relating to school safety. And then we've been asked, as things are in back and forth with different negotiations, we've been asked to take a quick look at page 452, an act relating to expanding apprenticeship and other workforce opportunities. And we have Cameron Wood from the Department of Labor coming in just to talk about a brief section of a bill, just to make sure that we're all moving forward, going in the same direction. With that, Ms. St. James, you have a side-by-side for us on school safety bill. Helps us to understand what we put in Senate Education and then what House Education proposed. And I think we may have one amendment to this bill as well. The good news is, and I believe the chair of House Education is aware of this, so if we get this out on Wednesday or Thursday, they can take it up and hopefully concur during the veto override session. It's just an option that we have going forward with a couple of things. So with that, Ms. St. James.
Thank you. You all should have Beth St. James, Office of Legislative Counsel. So I guess we'll just look at the side-by-side I prepared, which is S-138 as passed by the Senate.
APES, I didn't know what that meant. Thank you.
As passed by the Senate.
Well done.
I can't take credit for that. And the House Education's, when I prepared this, it was just their proposed amendment, but I believe it passed third reading today, this morning. So this is the language that you will be getting. There were no further amendments. So the first section, there was the House did make us, I don't want to call it small because it is a substantive amendment, but you'll see it highlighted there on the first page. So remember, this is the requirement that there be an option-based or a options-based response drill policy and conduct a requirement that schools conduct those. The Senate version, the language you all passed out, it highlighted in yellow, is the policy shall require option-based response drills, including fire drills, to be conducted following guidance issued, etc. The House's version adds, so the policy shall require age appropriate, so they add the term age appropriate option-based response drills to be conducted following guidance issued by the Vermont School Safety Center jointly with the Vermont School Crisis Planning Team. That's the same. And then their second addition here is, and shall require notification to parents and guardians not later than one school day before an option-based response drill is conducted. So the requirement is the same, except now there's a modification that the options-based response drills need to be age appropriate, and a requirement that notification goes out to parents before the drill is conducted. The rest of this section remains unchanged. They did not make any changes to any of the other pieces here. Page 3, if you want to skip to page 3, section 2 remains unchanged. The House did not propose any changes to section 2, nor did it propose any changes to section 3. So on page 4, the very bottom of page 4, section 4, they proposed a lot of changes. So keeping the title.
So on 4, page 4, okay, yeah.
So the highlighting here is not going to be super helpful because it's a little all over the map, and
I have no highlighting on my page 4.
there is none yet.
Oh, okay, great. Okay.
I'm just at this whole section. There is a little bit of highlighting to point out big changes, but I will do my best to point out differences here. So this, the House is proposing to keep section 4, the title of it the same. So creating a new statute called Behavioral Threat Assessment Teams, but it adds, it changes it. If you all remember what you passed out, if you want to look at page.
Yeah, I see.
So actually, we're going to go all the way to page 7. This is your subdivision A. What you all passed out is a requirement that if schools are currently using an option-based response team, then they have to provide training and collect data. The House amendment requires, I'm sorry, not option-based, behavioral threat assessment teams. The House version requires behavioral threat assessment teams and then creates a whole bunch of policy and procedure behind that. So we're just gonna, I think it would be most helpful to walk through the House language, and then I'll orient you to corresponding concepts for language in the Senate version. So the House version starts with legislative intent section, there's subsection A. It is the intent of the General Assembly that behavioral threat assessment teams be used for the purpose of preventing instances of severe and significant targeted violence against schools and school communities, such as threats related to weapons and mass casualties and bomb threats. The goal of these teams, I'm on page 5, is to assess and appropriately respond to potential reported threats to school communities. It is the intent of the General Assembly that use of behavioral threat assessment teams shall not contribute to increased school exclusion or unnecessary referrals of students to the criminal justice and school discipline systems, and shall not disproportionately impact students from historically marginalized backgrounds, including students with disabilities. So that's a piece of legislative intent. There is no similar provision in the Senate passed version. Subsection B in the House version, in that right-hand column, is a policy requiring development of a model policy. And the Senate version did not require development of a model policy. It just required training if a school was using it. So I've marked this as no similar provision in the Senate. So again, looking at that right-hand column, subsection B on page 5, there's a definition of behavioral threat assessment to mean a fact-based systematic process designed to identify, gather information about, assess, and manage dangerous or violent situations. Subdivision 2 requires AOE in consultation with stakeholder groups, including a commissioner of the Department for Children and Families, Vermont School Boards Association, and Vermont Legal Aid Disability Law Project, to develop and update a model behavioral threat assessment team policy and procedures. And in developing that model policy, AOE has to follow guidance issued by the Vermont School Safety Center on best practices. And the model policy and procedure shall require law enforcement contact in the case of imminent danger to individuals or the school community, and shall address the following. So the policy has to include criteria that shall be used to assess the student's threatening behavior, the process for reporting threatening behavior, the civil rights and due process protections to which students are entitled in school settings. I'm going to go on to page 6. When and how to refer to or involve law enforcement in the limited instances when such referral is appropriate, which shall not include student behavior that is a violation of the school conduct code, but that is not also a crime. And the support resources that shall be made available, including mental health first aid, counseling, and safety plans. And then each school district and each independent school, so both approved and recognized independent schools, have to develop, adopt, and ensure implementation of a policy and procedures for the use of behavioral threat assessment teams that is consistent with and at least as comprehensive as the model policy developed by AOE. And then any school board or independent school that fails to adopt such a policy or procedures shall be presumed to have adopted the most current model policy and procedures published by the Secretary. The Vermont School Safety Center shall issue guidance on best practices of behavioral threat assessment teams. And the guidance shall include best practices on bias and how to reduce instance bias developed in consultation with the Office of Racial Equity. So that is the requirement that AOE develop a model policy, the requirements of what should be in the model policy, and then a requirement that school districts and independent schools adopt their own policy that is consistent with and at least as comprehensive as the model policy. And then all of that will be based on guidance issued by the Vermont School Safety Section. Subsection C, we're still on page 6, is the most analogous to what the Senate passed, but it's not completely the same. So this is subsection C is on discipline and student support. So you'll see the Senate language on the left-hand side there was a requirement that behavioral threat assessments not be used for punitive or disciplinary purpose. And then there was language about what would happen if a student was on an IEP or had a Section 504 plan, and that was a requirement that a behavioral threat assessment not replace the manifestation determination review process as required under the Individuals with Disabilities Education Act or state board rules. And then if we shift to the House version, this is similar topic, but it's different. So consistent with legislative intent, subsection A of this section, if a behavioral threat assessment team recommends, in addition to providing support resources, any action that could result in removal of a student from the student's school environment pending or after a behavioral threat assessment, the recommendation shall only be carried out in a manner consistent with existing law, regulation, and associated procedures on student discipline pursuant to section 1162 of this title, which is about exclusionary discipline, and the same rules the Senate version is referencing on pupils and exclusionary discipline, as well as federal, and I'm on page 7 now, as well as federal and state law regarding students with disabilities or students who require additional support. So again, the Senate version specifically refers to IDEA and Section 504 of the Rehabilitation Act. The House version just references state and federal law regarding students with disabilities. And then further on the House side rather, on page 7, subdivision 2, behavioral threat assessment shall be structured and used in a way that is intended to minimize interaction with the criminal justice system. Law enforcement referral and involvement may be appropriate only in cases involving threats, which shall not include student behavior that is a violation of the school conduct code, but that is not also a crime. And then there is a training. So the next section of the House amendment is a training piece, and that is that course would correspond most closely to what was in the Senate's subsection A. So what you started with in this section. So the Senate language on the left-hand side reads each supervisory union or supervisory district and each approved independent school that utilizes the threat assessment team shall ensure members of the team receive training at least annually in best practices, as well as bias training. And providing the bias training, school officials shall consult with the Office of Racial Equity. And then on the House side, a very similar provision. Each supervisory union, supervisory district, and approved or recognized independent school shall ensure behavioral threat assessment team members receive training at least annually in best practices, as well as bias training. And then the difference is the House version spells out very explicitly what needs to be in that training. The annual training shall include the
Do you have a question, Senator Wood?
So is that training already in existence?
Parts of it may be, but I think it will make sense if we walk through the rest of it on developing it. The pieces might be there. So the annual training has to include rules governing exclusionary discipline, which is the that's the official title of the rules, the state board rules entitled pupils. The purpose and use and proper implementation of the manifestation determination review process. Section 504 of the Rehabilitation Act of 1973, the Americans with Disabilities Act of 1990, and other civil rights laws. The negative consequences of exclusion from school, the impact of trauma on brain development, and group bias training, specifically focused on bias and carrying out the duties of behavioral threat assessment team. And then subdivision 2, the Agency of Education, in consultation with the Department of Public Safety, shall develop guidance and resources to assist supervisory unions, supervisory districts, and independent schools in providing the annual training required under this subsection. In developing the guidance on bias training for behavioral threat assessment teams, the agency and department shall consult the Vermont Office of Racial Equity. So that's the training piece. The next section is data reporting and collection, and you'll see that this the first chunk above the highlighting. So I'm looking at subsection E on the House side and D on the Senate side. That's all the same up to the highlighting at the very bottom. So both both versions require that annually each supervisory union, supervisory district, and independent school report data related to completion of and outcomes of all behavioral threat assessments and manifestation determination reviews to AOE. And then at a minimum, the report shall include, and the items 1 through 3 are the same in both versions. The names of the members of the team, the number of behavioral threat assessments and manifestation determination reviews conducted in the preceding year, and for each assessment or review conducted, a description of the behavior requiring assessment, the age, grade, race, gender, disability status, and eligibility for free or reduced price school meals of the student requiring the assessment, and the results of each assessment or review. And then the third item is the number of students subjected to more than one behavioral threat assessment or manifestation determination review. And then what we're going to walk through next is all additions. The House is adding these requirements to the data collection. The amount of time a student is out of school pending completion of a behavioral threat assessment. Information regarding whether a student subject to behavioral threat assessment was also subject to exclusionary discipline for the same behavior, including the length of such discipline. On page 9 now, information regarding whether law enforcement was involved in behavioral threat assessment, information regarding whether the threatening behavior was also reported to law enforcement, and any additional data the Secretary of Education determines may be necessary. That's section 4. So that's the House's proposed changes to the behavioral threat assessment team. That would be in the green books, along with all the rest of S-138 and the options-based response drills and the visitors policy, etc. The rest of this is session law for implementation of behavioral threat assessment team. So any questions before we dig into that? Okay. So section 5, I'm on page 9. There's no similar provision in the House bill. There was no kind of transition language. But section 5 in the House version is behavioral threat assessment team's implementation. So the first subsection here is direction on the timing of the creation of the model policy. So subdivision 1 requires AOE on or before November 1 of 2023 to issue for public comment a draft model policy and procedures for use by the behavioral threat assessment teams. On or before December 15th, AOE shall issue, publicly post, and communicate to school districts and independent schools the final model policy. And school districts and independent schools currently using behavioral threat assessment teams shall update and implement a policy on the use of behavioral threat assessment teams consistent with the model policy no later than the 24-25 school year. And then, so that's the policy piece, and then the establishment of the team piece is, and training is subsection B. So school districts and independent schools not already using behavioral threat assessment teams shall take all actions necessary to establish a team not later than July 1, 2025, including, so by July 1, 2025, they have to have the team in place. Prior to July 1, 2025, this is all the work they need to do. Identifying and training team members, which shall include group bias training and the training requirements that we just walked through. Adopting a behavioral threat assessment team policy. Establishing procedures for proper, fair, and effective use of behavioral threat assessment teams. Updating and exercising emergency operations plans. And providing education to the school community on the purpose and use of behavioral threat assessment teams. So that's what schools who do not currently have a behavioral threat assessment team need to do before July 1, 2025. And then subdivision 2 on page 10, school districts and independent schools that are currently using behavioral threat assessment teams shall certify compliance with the training requirements that we just walked through on or before the first day of the 2023-2024 school year. And then AOE and the Department of Public Safety shall issue guidance and offer training necessary to assist school districts and independent schools with implementation of this subsection. So AOE and the Department of Public Safety have to help everyone get up and running. And then subsection C on page 10 requires AOE to establish guidelines necessary to collect all of the data that we just walked through. And then each supervisory union or independent school that is currently using a behavioral threat assessment team has to comply with the data collection requirements beginning in the 2023-2024 school year. So if you're already up and running, then you have to start giving the data. And then there's a report requirement at the very bottom of page 10. It just says reports in subsection D. So we're going to move to page 11, subsection 1. On or there's 3 reporting requirements here. On or before January 15th, 2024, so the beginning of next legislative session, AOE, in consultation with the Vermont School Safety Center, has to issue a written report on the status of the implementation of the duties and requirements of the Behavioral Threat Assessment Team statute, including the status of the development of the model policy, updates to training and guidance documents, updates on training and professional development requirements for behavioral threat assessment teams, data collected or voluntarily reported to the agency or center, the guidance issued, training developed, and measures implemented to prevent a disproportionate impact of behavioral threat assessments on historically marginalized students, including students with disabilities, to ensure that use of behavioral threat assessment does not increase use of school removals or law enforcement referrals for these populations, as well as plans for future training and guidance, and any grants or funding secured to support the implementation or proper use of behavioral threat assessment teams. So that's the first reporting requirement. The second reporting requirement is for not this coming legislative session, but the following. So on or before January 15th, 2025, so the beginning of the next biennium. AOE, in consultation with the Vermont School Safety Center, shall issue a written report on the status, again, of the implementation of the duties and requirements of the Behavioral Threat Assessment Team statute, including the status of data collected from supervisory unions and independent schools in the 2023-2024 school year, completion of the development of the model policy, and additional guidance, training, and other measures to prevent disproportionate impacts on historically marginalized students, including students with disabilities, as well as plans for future training and guidance. And then the last reporting requirement is on or before January 15th, 2024, so next year, AOE shall submit a written report with any recommended legislative language from the policy stakeholder work undertaken during the creation of the model policy and accompanying guidance and training materials required pursuant to the Behavioral Threat Assessment Team section. So as those stakeholders are working on the model policy, if they feel as though there needs to be additional language in law or changes to it, this reporting requirement requires them to come back and tell you about that next year. So the statute itself, section 4, would not take effect until July 1, 2025. And then section 5 is going to take effect July 1, 2023, this transition language. And you see that there's all kinds of different due dates in there for when, depending if you don't have a team currently up and running or you do have a team currently up and running, you may have to start complying with different parts of the Behavioral Threat Assessment Team statute prior to July 1, 2025. But all of that transition language gets everyone online by July 1, 2025. And that was the change made by the House, and they did not make any other changes to the effective dates. But in the Senate version, the section 4, the Behavioral Threat Assessment Team, did have an effective date of July 1, 2024, so this just moves it out a further year.
Great job.
Quick question. I know that the names of the members of the Behavioral Threat Assessment Team have to be reported, but is there any requirement that says who or how many people have to be on the threat assessment team? I can't remember if that was in our version or any version.
It's not. So in the Senate version, you did not require anyone to have a team. You just required training and the reporting of certain data if there was a team. And in the House version, the data required is the names of the members of the behavioral assessment team. I suppose theoretically the model policy may take into account who should be on the team or that, but neither the House or the Senate version specifies who should be on there.
Okay.
I don't really have a question, I have some comments, which are that I really want to thank the House. I did a close read on this last night, and I really want to thank the House for the work that they did on this, and the AOE as well. It seems as though they added some very deliberate and thoughtful guardrails and definitions and expectations of what these groups or these teams will do. And I'm really, really happy about that. You all have seen, I've had an arc in my thinking about all of this. Originally, I was just very wary of doing something like this, and I was very concerned that it would target kids with disabilities and just kids from historically marginalized communities. Then the shooting happened in Nashville, and I had to go to my local elementary school and speak to my 4th grade class about guns and safety. And it was hard to see, the fear in children. Obviously, our state and our country needs to grapple with and fix the gun issue that we have, which is completely out of control. And we also have to work on our mental health systems, which are just exacerbate all of this. But in the end, I had suggested bias training, and I see that it's in here, and that's even been beefed up and given even more greater definitions. So in the end, I'm happy with the work that was done, and I do think I will support this. So thank you for presenting it to us.
Senator Williams.
I'm just gonna make a statement. This is a lot to unpack. And I think that it's almost in the too hard box for this year. I really think we need a safety policy, a school safety bill that protects the students, because the clock is ticking. And, fortunately, it hasn't happened to us in Vermont, but it could be. And I think we should do something, even if it's wrong right now, and then build on that. Because I really question whether AOE can do everything that they've got to do in here in the time period we've given them. And that's all I got to say.
Senator Sheehan, where are you on this? And remember, everyone, I think knows this, we can concur with further proposal of amendment. Either way, the timing is a little extra time because some of this can be approved finally by the House during the veto override, but wondering where everybody is.
I think I'll have a better idea by the end of the day.
Okay.
I have hesitations, but I also hear the points that are being brought up. So.
Yeah. Okay. Yeah.
My one last comment,
Please.
just to reiterate what Senator Williams said. I really do hope the AOE will provide the necessary resources to get this work done and done well, because we know in the area of resources, there are some schools and school districts that are really struggling. So this was very important to the AOE, so I hope they can back it up with all the necessary resources that are required.
Mr. Fisher, briefly, is this something the AOE can support
In terms of resources,
in terms of its role it's going to play in this?
for the record, Ted Fisher, Vermont Agency of Education, the agency's Director of Communications and Legislative Affairs. We would not have brought this proposal if we did not intend to fully resource it, both immediately upon passage as well as in the out years. And we expect to be having some conversations about the out years with our partners at the Department of Public Safety as well as the Governor's Office, and may have additional things that we ask for next year that help us support in this work. We also are committing, and I appreciate the support of the Office of Racial Equity and some others, committing to do some robust stakeholder work you see outlined there. I also have a growing list of interested groups, including some groups who do not currently support, who would be interested in having conversations should this pass. So our hope is to do some of that engagement process, understanding that there is a provision in there for us to bring statutory requirements, but also hoping that they might give us their best thinking in development of some of the things like model policies, training and guidance and things like that. So yes, it's going to be a big job of work, and we're already talking about that, how we're going to resource it. It is not finished drafting. I was hoping it would be by now. We will issue in written form, but I would be happy to speak to it in response to Senator Hashim's question on Friday. Some testimony in the form of testimony outlining how this fits in with the district quality standards, which you directed us to establish last year, which provides a regulatory construct for business management, school governance, and facilities, school facilities and safety. And so this would be someplace where we would have some regulatory authority under that construct. So we're going to spell that out for you as well. And that's a big job of work that we undertook last year that we're going to continue building on. So we see these as very complementary internally.
I echo Senator Gillick's comments. I think the House did a deep dive on this, really good job. Also, and hoping that we could get somewhere where we could maybe not make a lot of changes, but possibly send it back with for the proposal of amendment. But leave it right now, right there, and we'll give Senator Hashim some more time, Senator Williams some more time to review it, consider it. Ms. Seelig. Sure.
Good afternoon.
Seelig, good afternoon. Welcome to Senate Education. I guess this is maybe for the room. Kind of getting mixed signals from people in the hallway, where they're at, where they're not at. I thought we'd all sort of come to some kind of agreement. Can you just let us know a little bit about where you're at and tell us your concerns at this point?
Sure. So for the record, Rachel Seelig, Director of the Disability Law Project of Vermont Legal Aid, as well as our staff attorney for government relations. Again, I'm sorry I'm not there in the room with you today. I think you all heard from me what my concerns are about behavioral threat assessments in the first half of the session. Since then, I think we've worked really well with the agency and with other stakeholders, including the Superintendents and Principals Association, to add a lot to this legislation that while I'm still concerned, I feel like we've got some guardrails in place and some data collection in place that allows me to say that I do think, understanding the important balance between needing to keep schools safe and school communities safe from really violent incidents, and the important work of protecting the civil rights of the kids in our schools. I think we've really moved forward in a productive way here. One of the things that I raised with all of you early in the session was that behavioral threat assessment was not defined in this legislation. It is now defined. Mm-hmm. Another concern that I had was what types of threats are appropriate to use this particular approach with. And what you have in front of you limits the use of this approach to severe and significant targeted violence against schools and school communities, such as threats related to weapons and mass casualties and bomb threats. As you heard kind of in the side-by-side, there's a requirement for creation of a model policy with stakeholder involvement. We're not talking about mandating these teams anymore starting in 24. We're pushing that off to fiscal year 25. But beginning the data collection for districts that are currently operating these teams now in this coming school year. And I think that's really important because we will have at the end of the 23-24 school year data on how often these teams are being used, what students are being subject to these assessments, and we'll have real live information about whether the concerns that I have because of how these have been implemented in other states are playing out in our schools in terms of disproportionate impact on students with disabilities and other historically marginalized students. You also heard that there's expanded data collection requirements here so that I think we will have a really robust picture of who these teams are being used with, what the relationships are in practice to school exclusion and criminal justice referral. And that will allow you all to be able to make more informed decisions moving forward about how these teams operate and whether you'll want to further amend Title 16. I'm also really reassured by the significant training for anyone participating in a behavioral threat assessment team. The training is now no longer just how to do a behavioral threat assessment, but to really understand how these assessments relate to discipline, the manifestation determination review process for students with disabilities, civil rights overall, and how those apply in school, issues around trauma and brain development that can lead to students having behaviors that may very well look like threats, but not be threats. And the consequences for students of school exclusion, as well as the bias training that you all had put in this legislation before it moved over. And that's all going to be required even before the mandatory implementation date. And so again, if that information, if that data is collected and we find that there really are some significant disproportionality or other kind of problems that lead to concerns about civil rights violations, you'll have that information and you'll be able to make more informed decisions moving forward from there.
Great.
And so I'll just finish by saying there is one area of ongoing disagreement, and that has to do with the order of operations between a potential behavioral threat assessment and the manifestation determination review. And so what you have in this legislation is a direction for all of us stakeholders to work with the agency over the summer and come back to you with a proposal in January on how to resolve that disagreement. And I think that given that these aren't going to be mandated in 2024, that gives us and you the time to really think through that kind of thorny issue in a way that the pressure of the legislative session just hasn't allowed us to get there. So I still have the concerns that I've expressed to you, but I do think that what you have in front of you takes a lot of steps forward to create some guardrails. And I'm really encouraged by the engagement of the agency and of stakeholders in really wanting to work together to protect the interests that we all have, both in keeping our students safe at school and making sure that their civil rights are protected.
That was great testimony and a good way for all of us around the data collection, what's going to happen before it's implemented. Very helpful. Any questions for Ms. Seelig? Comments? Rachel, I really appreciate it.
Absolutely.
It was very helpful. Very helpful.
Thank you.
Okay, committee. Anything else on this at this point? Give it some thought and just need to take some action on it tomorrow.